Welcome to Lawyers Without Billboards, where we break down family law and other areas of the law. No gimmicks, no legal jargon, just real, unfiltered talk from real lawyers. Join your hosts, Steve, Patty, Jimmy, and Alexa, partners at Shewmaker Lewis, a law firm based in Atlanta, Georgia. Every episode, they tackle the legal questions that matter most: divorce, custody, child support, alimony, and everything in between. They'll pull back the curtain to give you real insights on what happens inside the courtroom and beyond.
This is Shewmaker Lewis, Lawyers Without Billboards, the newest edition, right? Here we go. We're like New Edition.
No,
we're not like New Edition. Wasn't that your favorite band when you were
Jimmy's
23 years
band.
old, Jimmy?
Yes, it
Dude,
was.
I don't
Edition.
even know what that is.
You don't even know what that is?
No.
I've heard of it, but I have no idea what that
So
is.
you say. So here it is, big news at Shewmaker Lewis. Jimmy and Alexa just got back from their trip to Switzerland.
We did.
That's right. Did y'all feel very neutral while you were there, not like strongly in favor of anything, one way or the other?
It has a
right
very
middle of the
calming
road.
effect.
Does it?
You land and you're just like, I just feel really okay.
And did Jimmy try to set up a Swiss bank account?
He did not.
I just remember that scene in The Wolf of Wall Street, Leonardo DiCaprio talking to that Swiss guy about setting up accounts, and they're both kind of like being real cryptic with each other. I'm like, that's Jimmy at the bank in Switzerland, isn't it?
We didn't visit a single bank, unfortunately.
All right.
Sorry to disappoint.
That's cool. What are we talking about legally right now? What's up today, Jimmy? What's the topic?
We are talking about jury trials today.
Jury trials. Say it isn't so.
In family law?
And family law.
In
'cause
divorce?
it isn't so in Alabama. It
No.
isn't so in Florida.
Well, good thing we're not in Alabama or Florida.
It isn't so in South Carolina. But why are we talking about jury trials in Georgia?
Because this state is one of the few that will let you still actually do that.
One of the few?
actually file a jury demand in a divorce.
One of the few? I think it's one of the
One
two.
of the two.
Is it just us in Texas now?
It is just us in Texas.
I thought in Virginia, for certain things, you could also have a jury trial. Am I wrong?
I think you're incorrect.
Okay, I
but
could be.
maybe someone from Virginia will disabuse me of my ignorance. But I think that we are one of the only two states. But it's remarkably different because in Georgia, Jimmy, what can a jury do in a divorce case?
They can't do custody like they can in Texas.
Well, you're getting ahead of me, but there you go. All a jury can do in Georgia in a divorce case is what?
Property division, alimony,
Debt.
debt, and income for purposes of child support.
Right, and
That's
not
right.
just the income for purposes of child support, but all the inputs too.
Yeah.
Right.
If you've ever done a jury trial on child support, that's the jury trial that we did, and we had to do the child support. We had to had the jury determine the income, and then have them determine the adjustments, the medical
Right.
insurance, the child care, and then have them determine the deviations.
Can you guys imagine now that we're changing the law as far as child support for the parenting time adjustment, taking that to a jury? Here, guys, here's a calendar. Fill it out. Good luck.
Well, I don't think
Right.
anyone's done it yet. But let's take a step back here. If you're a layperson listening into this, and you're thinking about getting a jury demand, if you're thinking about making a jury demand for a jury trial, or doing a jury trial on your own, as we've seen some people do without their lawyers, well, I mean, you just have to know a few things off the bat. The jury, first of all, like Jimmy said, can only decide division of property, division of debt, determination of incomes. But what it cannot do is, decide who gets a child, right?
Mm-hmm.
Okay. It also cannot decide who's going to repay who attorney's fees, if
Yeah.
at all, right?
Right, that's a judge issue.
That's a judge issue. So certain issues stay with the judge anyway, and some people might say, well, that's not fair. And the answer I would give them is, well, in 48 other states, a jury can't do diddly. They can't do
Right.
anything in a divorce. Now, what can a jury in Texas do? Custody, but not property. So it's the
Right.
exact opposite of how Georgia does it.
Which feels crazier to me.
Which is wild.
Yeah.
Well, if you ask me, what's the rhyme or reason? Why does Georgia do it this way and Texas do it the exact polar opposite? I'm just going to look at you and say, I have no idea. Do you?
Oh, no. You grew up in Texas.
I grew up in Texas. I did. I actually, not only did I grow up in Texas, I got divorced in Texas. But all my exes live in Texas. That is
but
true
not by
statement.
a jury.
No, but not by a
Obviously.
jury.
You only have one, so technically that is accurate.
Yeah.
I only have one that you know about.
Oh, boy.
we don't.
We only have one that Patty knows about.
No, we don't care.
Well, actually, when I was in the Army, I went to Korea. I was only there briefly, and I
Oh,
married
boy.
a Korean girl and divorced her.
In
And-
Korea?
No, I just made that up. I would be a total loser if that had happened to me. Anyway, so moving on, the point is that you have to know where you are, what state you're in. You can't just get a jury because you want one.
Wait.
Yeah.
How would you not know where you are?
Well, Patty, where you are is where you are.
Okay.
That was like the dumbest thing, right? You have to know where you are.
Okay, it's early in the morning on a Saturday, and you're critiquing what I'm saying is dumb? Okay. All right,
Anyway,
I'll tell you what.
moving on.
Let's move on.
right.
Okay, so
Do you ever advise your clients to go to a jury trial?
I'm about to advise 2 of my clients in front of the same judge in Fulton County to make jury demands. So
Okay,
yes.
well, that's a why? Why would you do that? Why would you ever take divorce to a jury trial?
All right. So the first question that we came up with when we were planning this podcast is, can you request a jury in a divorce trial in Georgia? And yes, we've answered that. The next question is, should you? Because one of our firm maxims, one of our firm philosophies is, you will get what you may get what you want, but will you want what you get? Which is something we say all the time. So you can have a jury trial in Georgia, but do you want one? Should you have it? So Jimmy, give me one good reason to have a jury trial.
The circumstances of the case, you may end up doing better in front of a jury than you may in front of that judge.
Why?
For example, if there has been a prior temporary order that was not favorable to your client, and you think that you stand a better chance in front of a jury with those facts, that may be ideal to your client for their outcome to do that.
I have a client right now down in Warner Robins, just 30 miles south of Macon, and he had a temporary hearing in front of Judge Lukemeyer down there, and it did not come out the way he wanted. Now, I wasn't his attorney at the time, but shortly after that hearing, which was all about child custody and child support, so all that was left was division of assets, money, stuff like that. Shortly after that, he called me and he says, I want you and I want a jury. I don't like the judge. I'm not happy with what the judge did, so I want to hire you, Shewmaker, and I want a jury. And I said, okay, so you don't have faith that the judge is being fair to you. Now, it could be because, I'm not talking about that client, but it could any client could be reading it incorrectly. It could be because they're being a jackass. But one way or the other, you don't want to put your hands in the fate of a judge, so you'd rather put your hands in the fate of a jury. Is that what you're saying?
Yep.
Okay. Alexa, give me another reason why someone might want a jury trial.
Delay.
Delay.
Whether they actually want the jury trial or not, filing a jury demand is generally going to push the case out probably really far.
Why?
Because getting on a jury trial calendar is incredibly hard.
Why?
Because generally a lot of judges have very select times of the year that they'll take jury trials, and there's probably a lot of other cases, criminal cases, things like that'll take priority.
Okay.
And that's unfortunate because I actually see that a lot where attorneys don't want to go to trial. And so they will file a jury demand on the eve of trial just to push out the case because the judge won't continue it otherwise.
Do you see it a lot? I don't see it a lot.
I'll tell you, in the last couple of years, I haven't seen it as much, but
Right.
early on in our practice, I would say that we saw it more often. And I think part of the reason is because there's some judges out there, and the word got out, that if you filed a jury demand, the judge wouldn't let you withdraw it. And the judge said, okay, if you want to file a jury demand, okay, then we're going to do a jury trial. And you were locked in.
And I have one right now where the opposing party is a personal injury attorney, and he's representing himself pro se. So, of course, he filed a jury demand, even though the issue is pending before the court of custody and child support.
Because he doesn't know better.
He is and I've expressed in our email communications with the court where they verified he wanted a jury that, well, judge, we're gonna we're gonna have to bifurcate the trial because the issues before the court are this, and the court can't hear that.
Well, let me give you guys one. It's my turn. Similar to what Jimmy said. You may have a client that's had an experience with a judge and it didn't go well. What if the client's had no experience whatsoever with a judge? Would you, as the attorney, on certain occasions, other than to delay a case, Alexa, other than that reason, would you advise a client to go with a jury?
Possibly based upon experience. If you know that a judge is heavily favored in one particular aspect of that, and that's a central part of your case, that may be ideal to do that.
Okay, so let me throw out an example. What about with the example of alimony awards? Explain how that might work.
Okay, so if your case is in front of a judge who is notorious for not giving out any alimony, and your client is the stay-at-home mother who hasn't worked in 20 years and husband is bringing home $500,000 a year and easily has the capacity to pay, but this judge is notorious for being ridiculously strict on it. Is that going to be worth it to take it to a jury who may be far more sympathetic to your client? Probably.
Maybe.
Okay. What about, Alexa, let me turn to you. I like that. That's a good answer. It's a perfect answer. Alexa, let me ask you, what about bad conduct and going for a jury rather than a judge?
Well, I think that depending on your judge, if you have a judge who really doesn't care about bad conduct, which a lot of judges get really desensitized, regardless of how extreme you think the bad conduct is, if you take it to a jury, it's possible that they're going to be more sympathetic with the bad conduct because they might be a little more outraged. They don't see this every day.
Yeah, I would agree with Alexa because I think based on the jury trials that we've had, the juries tend to be more concerned about bad conduct, whereas judges, they get desensitized, so it's not as big of a deal to them.
Yeah, and I think we've talked about that in some previous episodes, how judges are basically presiding over the Jerry Springer show in court, so the bad conduct has to be amazing, and it's got to involve midgets and mules and stuff for a judge to even take notice because they're so desensitized, not because they're bad people.
I haven't had that case, but
not because they're bad people, but because they're just bombarded with really, really bad stuff. So I think you guys are right now, but I will ask you this. That also has another aspect to it, which is the selection of the jury. I mean, if you want to really get people motivated about bad conduct, I mean, your potential jurors you're looking for like the church lady on Saturday Night Live, every one of your jurors.
And, the challenge with that is, because we've done several jury trials among the four of us, and the challenge is, you sit down with, your trial strategy and you think about, okay, who's my ideal juror? Who do I want on the jury? And you go in and you go to jury selection and you're like, oh, we want this person, this person, this person, this person. And, of course, all the ones that you want, the other side doesn't want.
Right.
So you never really get who you want on the jury.
Well, that's true. And as Jim Holmes, who's of counsel to our office, he's the old gray-haired guy in our office.
Yeah.
And don't say anything about my beard right now. But
one of the old gray-haired guys.
Jim Holmes is fond of saying that when you pick a jury, you're eliminating the people you don't want, and the other side's eliminating the people they don't want. So what you're left with is the leftovers.
Yeah, that's your jury, the leftovers.
Yeah, leftovers.
All right, so we've talked about can you have a jury? Should you? Let's talk about the disadvantages of a jury. What's a big drawback to picking a jury?
Expense, yeah.
Okay, expense.
That's the biggest one.
What's a rule of thumb on the expense when it comes to a jury?
At least 5 times more than it would cost
What do you think,
than a
Patty?
bench
I
trial.
was going to say 3 times of a bench trial.
Yeah, I think it's 3 times.
Because our rule of thumb has always kind of been, look, for every hour in court, for a bench trial, we spend 2 hours of preparation. Yeah. For a jury trial, we would say every hour in court, you spend 3 hours of preparation. And oh, by the way, a jury trial is going to be longer because you spend a lot more time. I mean, you could spend half a day just picking the jury.
Well, correct. And let's lay out the terrain here. When you have a jury trial, prior to the trial, the extra work an attorney has to do is to prepare jury charges. Now, what is a jury charge, Jimmy?
It's basically talking about when the jury is going to take all the evidence in the back and what they are looking at to kind of the guiding law for the jury.
So there are instructions on the law.
Right.
Okay. That's what a charge is. So you have to prepare jury charges and submit them to the judge, don't you?
Yep.
Does anybody help you with these?
Well, there are pattern jury instructions in the law. We can hop on Lexis and pull up all the pattern jury instructions. Most of the time, that is going to cover a lot of things.
Yeah.
The last jury trial I had, there were some very nuanced real property issues. So I had actually created a few jury charges, which that resulted in a bit of a motions hearing.
Right.
Outside of the jury, obviously.
So judges are going to defer. They're going to lean towards the pattern jury charges that are propagated by Lexis and Westlaw because they're tried and true. But there are cases where you have to create them. Patty, you've had some experience with that.
Yeah, I've had some jury trials where I've had some unique issues, like Jimmy said, and there's not a pattern jury charge for the issue. And so I had to go to the case law, create the jury charge. And then what happens is, and this doesn't happen in front of the juries, you have essentially it's called a charging conference where the attorneys meet with the judge and you go over all the jury instructions or jury charges. And it's easy if they're patterned, but then you have these one-offs or these unique issues, and then you have to go over, and then you guys have, the attorneys and the judge have to kind of go back and forth over the exact language that's going to be given to the jurors.
Yeah, and so, for example, on one of mine, I knew that the other side was going to absolutely not want that in there. And so I made it very, very, very beefy. And then it got narrowed down quite a bit, but it still included what I wanted in there. So I was like, all right, here, fine. I'll agree to eliminate these portions, but we have to leave this. And the
look
judge
at
was
the
like, that looks fair.
tactician brain on Jimmy Lewis. You're like Hannibal with the elephants.
He's tactical.
The
You're like,
strategery.
you're like Rommel in
Strategery,
North
I
Africa,
like it.
man. You're just beautiful. You're beautiful.
Hey.
Damn, beautiful.
Blind squirrel.
Blind squirrel.
That whole thing.
All right, so one of the big differences is having to create jury charges, which you never, I would say almost never have to do in what we call a bench trial, which is just the judge alone. Now, another big difference is a thing called voir dire, right, which is about as much French as I took in high school. What in the hell is voir dire, Alexa?
That's the voir dire process is essentially when you're determining your jury. So you have a bunch of questions that you're going to ask your jury that'll help you eliminate people and determine whether or not you're going to strike them, whether or not they're too close to the case or they know somebody or their life experience is too similar that they shouldn't be on your jury.
Right. Now, voir dire questions, do you have to submit those to the judge in advance? You have to?
Depends on the judge.
Very good. I've had jury trials where the judge didn't ask, so we didn't produce them in advance. He just walked in and did them. Most of the time, a conscientious judge is going to say to the lawyer, send them to me in advance. Now, criminal trials and military trials,
Right.
you submit them in advance and you'll get them back all marked up. Judge will say, I'm not letting you ask this question, or you can ask this question this way. So,
Yeah.
and there's nothing that stops the state court judge in a divorce from doing the same thing.
And the whole point of voir dire, at the highest level is picking jurors that can be fair and impartial.
Yeah.
But the more strategic or tactical level is, you want to pick a jury that's sympathetic to your case.
Right.
Right?
Right.
So the law says, look, you have to have a fair and impartial juror, but we're not. We're looking beyond fair and impartial. We're looking for, we want you to be sympathetic to our story or our side of the story and side with us.
Right. Now, once a jury trial starts, and we've picked a jury, so we've got 12 people plus an alternate or two in the box, and we start the case, it's still the same as a bench trial. It's still opening statements, presentation of evidence, examination, cross-examination, closing arguments, all that stuff, right? It's no different, right? What's the difference with a jury there versus not a jury? And we've already covered time. Yeah, I get it. The jury has to have bathroom breaks.
Yeah. Lunch breaks.
You've got 13 different bladders there. They're all hungry. They've got to go to eat. And the judge has to give them liberal time to do that because every one of those jurors comes from the county, and they're going to vote for that judge or not. So the bottom line is, other than that, what's the difference? What's the big difference between a jury trial and not a jury during the trial itself?
Well,
There's a jury in the jury box, Steve.
You have an audience, essentially.
Common sense must appear like a superpower to Jimmy Lewis. Have you ever thought about that? No.
Objections. Some of your objections.
Evidence.
Yes,
All
some
right.
of your evidentiary
All right.
objections.
Okay, and I'm going to read to you something out of the Georgia Evidence Code that is so short, but yet so applicable here. The rules that say the rules of evidence, which we'll talk about in other episodes, are applicable. They apply. I'm going to read this to you. The rules of evidence shall apply generally to all non-jury trials. Okay? And the sentence before that is the rules of evidence shall apply in all trials by jury. But rules of evidence shall apply generally to all non-jury trials. So the state legislature has added the word generally when it's a judge without a jury. And I'm asking you guys, what's the difference between a jury trial and a non-jury trial once the trial commences? Does that help you?
Yeah,
Yeah.
the rules of evidence are much stricter in a jury trial than they are in a bench trial.
Because
The French
12
just said.
citizens can be led astray
Very
by
easily.
bullshit, which all attorneys,
Yeah.
even Jimmy Lewis, is prone to spewing. So, therefore, a judge may say, I'll hear everything. I've had judges say, I want to hear everything. I'll decide what's important. But that
Right.
same judge with a jury is like, no, we're going to follow the rules strictly.
Right. No,
right?
that's hearsay, regardless of the fact that I want to hear it.
That's Tom Davis right there from Gwinnett County. Tom Davis said to me and Patty one time, he says, it's hearsay. I think I object. I said, Judge, it's hearsay. He goes, yeah, it's hearsay unless I want to hear it.
Yeah,
Which
you don't
goes
get to do that.
Goes exactly to
Right.
what I just read out of the Georgia Evidence Code. Generally, the rules of evidence apply, but not as strictly. That is also a big-ass problem. We need a sound effect for a big-ass problem. What is y'all's...
It's not a problem. It's just a challenge, and
Right.
you have to. You really talk about
Well...
being prepared.
Okay. There are
Yeah.
people in the Atlanta area, the domestic law community, that will say, Steve Shewmaker, is judgmental and opinionated and obnoxious. And I will say, okay.
You got 3 people at this table who would say that.
Well, thank you very little. But I will say, what makes you say that? And then I will remind myself that I frequently have said that domestic attorneys are generally abysmally bad at knowing the rules of evidence.
Well, yes, but that goes back to exactly what you said, because most of what we do are bench trials, and the rules of evidence generally apply to bench trials, and so it's kind of loosey-goosey when it comes to evidence rules.
But what I'm saying is that there are sizable double-digit percentages of the family law bar in the Atlanta metro area where the rules of evidence, if they ever knew them, have devolved to the point that it's just thinking I could just bring anything into this courtroom, just blah, 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 blah. And I start shaking my head and I start pulling out the evidence code and start making objections that are good, okay?
Well, yeah, I don't disagree with you.
Okay, well, let's talk about that, because you will not do that in a jury trial. Because
No.
even most judges are going to say, no, we're not doing that in front of citizens. We're not going to let that happen, right? So that's a big difference right there. That is also the reason why, raise your hand if you've had people call you and go, my attorney so-and-so won't do a jury trial and I need a new attorney. Now you're nodding. Talk to me about that.
Yeah.
I was just saying
Yeah.
that's happened.
Yeah, a lot of attorneys are intimidated by it
Why?
because they don't know the rules of evidence. They don't know how to present a case in front of a jury, even though it's exactly the same. They're not confident in their ability to do it. Mm-hmm. And then you've got some lawyers who are way too confident in their ability to do it that probably shouldn't be.
You talking about me?
Well, I didn't say it out loud.
Now, Jimmy, you just recently did a jury trial, and it was your trial. I think I was there for the jury selection, but you handled it against 2 other attorneys, against, David Lipscomb and
Charles Medlin.
Charles Medlin, and those are experienced attorneys, and you held your own against them, right? Now, were you nervous?
Yeah, I feel like if you're not nervous, even if it's a bench trial, then you should probably just quit.
Yeah.
I agree.
That's fair
I
point.
agree.
If you're not nervous, you don't care.
Yeah,
I
agree
love
with
it.
that.
I love it. So the big differences, I would say, between a jury and a bench trial are the instructions that the jury gets, the voir dire process, you have to select the jurors, evidence rules, admissibility, stuff like that, which we'll cover in much more detail in other episodes, and the amount of time it takes, right?
Yeah, and what our experience has been in jury trials, and again, tell me if you disagree with me, but
I disagree. Oh, wait. What
well, you gotta let me.
Don't be disagreeable.
Yeah, you gotta let me say it first, okay?
Like the assembly said, generally.
do you got?
With jury trials, you talk about why doing a jury trial versus a bench trial, and we talked about that a little bit. What always concerns me about a jury trial is I know that the judge gives them the charges, the instructions, and advises them on the law and says this is the law and you have to follow the law. Do you really think that the jurors follow the law? No. I think it's more. What I've seen is it's more of a popularity contest between the parties.
I don't like that guy. I don't like that lady.
Yes.
I don't like that.
Her voice is annoying.
Her voice is annoying.
Right.
I don't like his face.
A lot of times attorneys will file jury demands because of the issue of alimony, right?
Yep.
And they'll think that they'll get a better alimony award from the jury, but then that, particularly alimony, which is so discretionary, don't you agree that it really turns on, do they like...
But I'm
Do
going
they like your client or not?
to tell you right now, Metro Atlanta, DeKalb, and Fulton, probably the latter more. I think we're seeing more jury trials and more arbitrations because experienced lawyers are telling their clients it's just not a good idea to go in front of this judge for any number of reasons. Now, and I'm being very blunt, does Shewmaker and Lewis do divorce jury trials?
Yes.
Yeah.
Okay, and a lot of firms don't, and we do them, and we take them seriously. We don't do them on a whim. We put time in and do them right.
Yeah, and we don't typically advise our clients to do jury trials because they are expensive, and you really have to weigh the cost-benefit analysis with the client on whether it's worthwhile.
That's true. That's true. Your jury trial is probably going to cost you 2.5 to 3.5 times as much as if we just did it without a jury. And you have to decide, is it worth it?
Right. Right. And if the concern is the judge, and the judge not liking your client, there are other alternatives. We're starting to see a lot more arbitrations where you're selecting a private arbitrator, and we're going to talk about arbitrations.
Talk about that another day.
Yeah. So there are other alternatives if the judge is a concern for your client.
Right.
Because the judge is still the judge on your case, whether you have a jury or not. They're just not making the exact same decisions they would be if it was judge alone.
Right. Now, there's a lot of things I'd love to talk about jury trials that we probably don't have time to. When you get into the issue of attorney's fees, can a judge dock the party who elected the jury in the first place?
They're not supposed to.
Well, they're not supposed to.
Supposed to.
And I've never had to make the argument to a judge that, my client exercised a constitutional right under the Georgia Constitution to have a jury, and you can't assess attorney's fees against a client for exercising a constitutional right. But as Patty says, a smart judge will keep their mouth shut and just find a legitimate reason to do what they want to do.
Right, under a different statute.
And that kind of begs the question, do judges like to do jury trials in divorce?
Most of them don't. They hate the idea.
Why?
Why? Because, again, it takes a lot of time. You can look at a jury. You can look at a jury who walks into a courtroom and sits down. The jury you and I had, Jimmy, same thing. And they're all sitting down. They're ready for a double murder. Who done it? And they sit down, and the judge says, this is a divorce trial. And you can see the look on their face like, damn, I can't believe this happened,
I got to hear about dining tables and bank accounts.
But I will tell you, from the experience of the jury trials we've had, one of the interesting things is sometimes you get a client that says, I want a jury trial. I want a jury trial. And then I like to tell them, well, we had a large asset jury trial in Walton County several years ago in front of Judge Samuel Osborne. And Patty and I did, and we chose a jury.
And he was a great judge to try a jury trial.
Sam Osborne has a mix of criminal and civil experience, and he is the kind of Southern gentleman that you want to try a case in front of because he doesn't raise his voice, he's calm, he's just a good guy. But in the midst of this case, we picked a jury, and damned if the foreman of the jury was not what, Patty? What was he?
He was a Hollywood stuntman.
A Hollywood stuntman, worked in the movie industry.
That was our jury foreman on a multi-million-dollar marital estate.
Yeah, this was about $18 million, I think, was at least the argument was that it was that much. And so we get these clients who come in and go, damn it, I want a jury trial. And I said, well, slow down, not so fast.
Yeah.
You want to take first of all, the best way to decide what's going to happen in your case is you and your spouse work it out.
Sure.
We help you work it out. If that doesn't work, we'll put it in the hands of a judge. Now, I just said that Samuel Osborne was a great judge, and I meant it. But there's a lot of judges out there that ain't Samuel Osborne.
Right.
Okay, they are far stretched below that level. And I tell people, you're going to put yourself in the hands of Judge so-and-so. Okay.
Yeah,
but
good
then
luck.
What's even more dicey than that is 12 people you've never met.
Right. And at least the judge presumably knows the law.
Right.
You got 12 people. I mean, what does a Hollywood stuntman know about the law?
I hear you.
All he's going to know about the law is what the judge tells him.
Right.
And the jury instructions. And those jury instructions are long. It's usually like 10 pages of instructions. Yeah. And you can see the jurors, you can see their eyes glazing over.
Yeah, it's still jargon. It's not like it's super dumbed down jury instructions either.
No, you're right. Anyway, we could talk all day about jury trials, and I'm sure the topic will arise again in other episodes when we talk about other aspects of the law. But, this is Shewmaker Lewis, and just to emphasize, we do jury trials in domestic cases, and we're more than happy to do them. I think, Alexa, you have one coming up in a month or so, don't you? August, yeah.
August.
And I have 2 clients that I believe are going to tell me in Fulton County to start asking for jury trials.
But I told you, didn't I? Mine's not a divorce.
Yeah.
Mine's a contempt action.
Case, yeah.
Yeah,
but it's a jury nonetheless.
That is true.
All right, so Shewmaker and Lewis does jury trials. We specialize or subspecialize in jury trials, and we're more than happy to talk to you. Before we end this episode, I must remind everybody that the music for this episode is put on by Ben Hernandez, my very own guitar teacher, and his company, Dragon Productions. And everything else about this podcast is run by Rob Bergner and Bleeding Edge Productions, and they do a great job. And I think that's it, right?
Yeah,
that's it.
All right,
See you guys
Shewmaker and
next
Lewis,
time.
peace out.
That's it for this episode of Lawyers Without Billboards. If you found this episode helpful, make sure to follow and subscribe on Spotify, Apple Podcasts, Google Podcasts, or wherever you get your podcasts. For more resources or to get in touch with us, visit shoemakerandlewis.com. Thanks for listening, and we'll see you next time.